I have spoken with the federal public defender for Mr. Shiflett. He's up in I guess in the county jail, but it's a U.S.
Yeah,
Western District federal
that's
case.
the way they work. They use the county facilities for their holding. So yeah, the Fed does.
Um, Mr. His criminal defense attorney is an attorney named Mr. Kurt May, and I've spoken with Mr. May. I think three times to kind of get a bunch of information on what's going on in his case. And the long and short of it is this. My understanding is that he has pled to the charges, and they're currently doing a PSI right now. Um, the offense that I guess that he pled to up there is a failure to register charge. The original offense was from Colorado, and he traveled interstate lines and failed to register when he got to Texas, or something to that effect. And he's required to register as a sex offender, obviously, in both places. So that's how he got the federal charge. After talking with Mr. May, it's my understanding that it's likely that I guess first the range of sentencing is 3 to 5 years in the federal Bureau of Prisons. Um, Mr. May indicated that it was possible um, for Mr. Shiflett to get 2 years, so that is a technical possibility, um, but not likely. And it seems like the judge will probably split the difference on the range and go with 4. Um, so uh, I don't believe he's going to get probation, but he hasn't technically been sentenced yet. So um, that's kind of where we are on that. I think the state would like to proceed on a default. I feel okay about it. My understanding is the sentencing. Mr. May was driving between courthouses. His office covers all the way from San Antonio to El Paso and to Waco, uh, the whole Western District. So he was he was in the middle driving between one of those three places when I caught him. Um, and he had said that he couldn't remember the
All right, is that me or is that Mr. Brimhall?
is
I
by
believe
the
that's Mr. Brimhall, Judge,
You had,
because he cut out
you
for
had
me
a
as
glitch,
well.
Mr. Brimhall. You were just speaking about the driving and you went off on us. So
Oh, did I cut out? Sorry. Yeah, well,
yeah.
I was talking to him while he was driving, but he couldn't remember the exact date of sentencing, but he indicated that it was for sure before the end of next month. So, but by the end of September, we'll officially know what the official sentence is going to be. Um,
Well, the bottom line is he's been in there more than 90 days. He's going to be in there more than 90 days after this because
yeah,
I really doubt he's going to get probation based on that charge. And
yes, yeah.
so I think if the state wants to go ahead and proceed and not wait, just go ahead and make sure that way the mom doesn't have to keep coming back for something that obviously she's not going to get any financial support from this gentleman for a while. So anyway,
The only
anything else, Mr. Brimhall?
yeah, my recommendation on a default would obviously be that his support be set to 0% to the family code, his current support that is, child and medical support. Um, and then the visitation be not ordered at this time
Okay.
due to currently criminal convictions. But the one thing I think this court can address and should address is the issue of retroactive child support. There are about 14 months from uh, December of 2023 until February of this year. I think that's 14, if I'm not mistaken. Maybe it's 15 months. Um, but those are the months that I've been able to ascertain where the parties were not living together and prior to his arrest for these charges.
Okay.
So about
Well, I'll
15.
see if Mr. Gwen's ready to go on that one as far as the day's concerned. And anything else, Mr. Raval?
No, just the issue of retro, I think is appropriate at this time. Um, my only concern, and it's probably not a realistic concern, is that if for some reason he doesn't get the expected years of jail time, then we'd have to come back and modify, I guess, to reset support. So that's my only concern about the default today would be if on the off shot possibility that he's not sentenced to years in prison, then we'll have to come back here pretty quickly to get
He's
it
gonna get
set.
that 2 years minimum, Mr. Brimhall. There's no,
Yeah.
yeah.
Yeah, I tend to agree with that. I tend to agree with that. I just that's just the very minor concern I have. Yeah, I think it's likely that I mean, his attorney indicated to me it was 2 years was possible, but not likely. So,
All right, then. Well, Mr. Green, what do you want to do, sir?
So the state had been ready to go forward, defaulted, set support at zero for obvious reasons. I mean, with that charge, there's no way he's getting away without a serious time. Um, in that consideration, I hadn't done a retro calculation. I would need a few minutes to do that if that's something that we're going to move for.
Yeah.
But
my
that's where I'm sitting.
my understanding on the job information, his prior job work history is it would be best if the court just defers to minimum wage calculations. I think he worked a little bit as a framer, a little bit as a landscaper, and a little bit at a Little Caesars and Temple. And I think each of those jobs was for less than 2 months each. So it's probably,
Okay.
I mean,
Framers make really good money, but if he didn't have that for a substantial amount of time, uh,
I believe
uh,
that, I
and
believe,
unless the state wanted to, well, those all should have, well, the state might want to talk to one of their financial people, see if there's any information on that. But again, yeah, it's probably not going to be that great if it's only 2 months at a time.
right. I think two of those jobs were in Colorado, either as like uh,
And Little Caesars is the only one in Texas that you know of.
yes.
Okay, then never mind then.
Yeah.
So, Mr. Quinn, do you have any other information other than that, sir?
I do not, Judge.
All right, then, ma'am, I'm gonna let the estate have a moment to go ahead and do his calculations to see what the retroactive child support should be. But I'll go ahead and go off the record for just that one moment, and once he's ready to go, we'll come back on and we'll get this one set up and finalized then. Because again, yeah, let's not make anybody
Yes,
else
sir.
come back. You know, if he get if he
Yes,
has
sir.
miracles, he gets out. Mom, call the AG and they'll file a new case on him. Okay. All
Yes,
right.
sir. Thank
Yeah,
you.
but just but
All right.
hold on, because you will need to give testimony as soon as the state gets that information ready to go. So it'll be about
Okay.
5 minutes. All right. So just take a moment. Thank you.
Yes, sir.
Thank you, Judge.
All right, and I'll stop recording for a moment. Thank you. We're back on the record on Bell County College number 24 DFAM 347. Whole truth and that, but the truth will help you.
Yes, sir.
All right, ma'am, the official oath, and I'll let the state go ahead and tell the court what specifically you're going to request we do here today as far as this hearing is concerned, and then confirm that with Ms. Torres and Mr. Brimall as headliner. Thank you.
All right, thank you, Judge. And state is largely in agreement with what Mr. Bremall had to say. We are looking to finalize this, basically to default him, set the establishment, set support at zero going forward, due to the non-custodial parent's current and pending incarceration for a federal offense, failure to register as a sex offender. I ran the retro calc for a period of about 15 months. It's going to come out to $232 per month, one child in, zero out on this order for a span of 15 months. And that will come out to $3,480 in retroactive payment. And whenever he was released from incarceration, that would be a $70 per month repayment.
All right.
Yeah, my requests are unchanged. I don't think the court can order costs. Just
No, I don't order calls that they're in jail.
yeah. On the repayment, obviously he's not going to be able to repay any of it until he's out. so the repayment feels not so important, the amount. I'd probably say that if he is able to work in jail, there may be a chance that um he can make a little bit each month, and so maybe the court might set it at like I know that folks that do
I'm
are
gonna leave where it is, but Fed's a little different, but let's not, I'm not gonna anticipate without information, Mr. Brumwell.
yeah,
Just,
I was gonna say usually
I'll let it earn interest while he's sitting there and, he'll have to
yeah.
pay it when he gets out, so.
Yes, of course. Yes. I was gonna say I think maybe he may be able to make a like a reasonable repayment for him in prison of like $5 to $10 a month, maybe. But that's a
Yeah.
real
Yeah, that's gonna, getting that set up and done is probably not going, it's just not gonna,
yeah,
it
I
costs
know.
more than he'll come in, so yeah, so.
Yeah, the income that inmates earn is generally well below minimum wage. Yeah. If they're allowed to even work at all. I mean some prisons
See, I
don't.
hadn't been in federal court in 20 years. I hadn't had to look at any of that, so I'm not up to date on that at all. So I understand. So let's
Yeah.
just leave it where it is. And when he gets out, we'll set up his new child support, and we'll set up his repayment of that at based on the the interest that's going to accrue. If he's in there 2 or 3 years, it's going to go up. Oh, yeah, about another $1,000. So yeah.
Yes. I think it will, yes. Easy for sure.
All right then. Anyway, anything else then, sir?
Um no, Your Honor.
All right then. Let's get some testimony from Mom, because I look at that name in her sole MC, him of possessory, her with all rights, him with none until further order of the court. And I'll let y'all go ahead and prove that with her. Thank you. You may proceed. Call your first witness. Call your witness at this time, Mr. Gwynn. Thank you.
All right, the state would like to call Victoria Torres.
Yes, sir.
All right, and please state your name for the record.
Victoria Torres.
And what's the name of the child that we're here on?
Janie Lee Hope Shiflett.
All righty, and does Mr. Shiflett have any other children?
No, sir.
He does not? Okay, so this is the only child?
Yes, sir.
All righty, and you are of the understanding that Mr. Shiflett is currently incarcerated, correct?
Yes, sir.
And he's pending further incarceration based on the charge he's currently locked up for?
Yes, sir.
And are you aware of what that charge is?
Yes, sir.
What is that charge?
Failure to register.
And when you say failure to register, you are referring to being a registered sex offender, correct?
Yes, sir.
All righty. And when, well, state is of the understanding that you and Mr. Shiflett separated on or about December 19th of 2023. Is that correct?
Yes, sir.
Okay. And Mr. Shiflett got locked up pending his current charge in February, late February of this year. Is that correct?
Yes, sir.
Okay. And you're requesting a retroactive payment be ordered for that time period?
Yes, sir.
And during that time period, did Mr. Shiflett provide any substantial support for the child?
He did before he got incarcerated. Yes, sir.
What support was that?
I'm sorry.
What kind of support was that?
He did give me about $200 before he went in.
Okay, so for that time period, he only gave you about $200.
Yes, sir.
Okay, so you would agree that a retroactive repayment be set at minimum wage?
Yes, sir.
And you heard the state telling the court that its math had set that amount to $3,480, correct?
Yes, sir.
And you're in agreement with that number?
Yes, sir.
Alrighty. And you're asking based on the nature of his charges, as well as the fact that he's going to be locked up for the next several years, that the court withhold any sort of rights to access and possession to the child, correct?
Yes, sir.
Alrighty. No further questions at this time for this witness, Judge.
All right, ma'am. I'm sorry, Mr. Brumwell, you're a witness. You muted, sir. There you go.
Yes, yes. I don't think I have any other questions that weren't already asked of this witness. I would just also ask the court to order that Mr. Shiflett notify the OAG and the district clerk when he's released.
We'll make that part of the court order, but he has to let them know within 30 days of release. That's the norm.
Mhm. And then I don't have any other questions about possession access or um, anything else.
All right then, ma'am. Here's what I'm looking at doing. I'm looking to go ahead and grant the state's request. I'm going to go ahead and we're going to make this a final. I'm naming you sole managed conservator based on the circumstances that the father's involved in. He's been a registered sex offender. I'm sorry, he's a registered sex offender and he violated his terms and conditions of parole and didn't register like he was supposed to. So at this time, I understand he is going to be in a federal facility for a minimum of 2 years, probably somewhere closer to 4. But I'll go ahead and name you sole managed conservator. I'm going to name him possessory. I have to do that. But under the possessory conservatorship rights, I ask the state to give him absolutely none and say until further the rights withheld until further order of the court. That way, when he gets out, we can see what his terms and conditions will be up on his release, because he still probably has to deal with something with the fact that he did skip out in Colorado, wherever the home state was, where he got the original charge. And so he's probably got to deal with that a little bit too. And there might be so I got to deal with federal matters and state matters before I know what I can actually order him to do going forward. But I will tell you, ma'am, as soon as you know he's out, please let the OAG know, and that way they can get ready. Because it takes a while to get this stuff up to speed, so they can start getting up to speed and see about getting child support and everything else set up. But until further order of the court, that's what I'll do. I'm going to name, no, there's no visitation. I'm also going to order no court calls due to the fact that the gentleman is incarcerated. So, ma'am, do you have any questions?
No, sir.
All right, is there anything else, Mr. Gwynn?
There's not, Judge.
Mr. Bramhall?
Nothing apart from my release after the entry of the order.
30 days after orders becomes final, sir, you are officially released. Anything else?
And Judge, maybe could we hold off on entry of the order for about 30 days, just so that the 30-day period after entry would enclose the sentence date, just in case I need to file like to reopen or anything?
I'll leave that to Mr. Gwynn. He did.
Yeah, just like have the signing at the end of the month.
No, we're not coming back on this one.
I know.
This turkey's on his way to the Thanksgiving table. Okay.
I know. I know. I just don't want to have to file a new motion in 6 months if there's that one chance possibility. You know, 1%.
Yeah, well, let's not worry about it. Let's worry about the ones we got coming up, and then put this one in.
Okay. All right.
Oh,
Fair enough. Fair enough.
Good enough. I know I'm like you kind of sort of a lot of times, but this one, no, he's
definitely, yeah,
going away.
yeah.
So
I understand. Yeah. I just figured the 30 days after would probably enclose the whole time period, but
yeah.
I understand.
All right, good enough then. Anyway, let's go ahead and get this one taken care of. And ma'am, Ms. Torres, the state's going to send you a copy of the paperwork to review and sign off on, and Mr. Bremont will get a copy. If y'all need to tweak anything, just let me know. But may Ms. Torres be excused at this time, Ms. Gwynn?
Yes,
She
sir.
may, and I would ask that all parties be basically watching your email, barring some unforeseen circumstance. I should have that order to you before the end of the business day. And once you get that, please do review and sign, or notify me if there needs to be some sort of a change made.
All right then. All right,
Yes, sir.
thank you everybody very much, and ma'am, good luck to you and your child. Obviously, the circumstances are not best, but yeah, I know you'll make the best of it, and take care of the child. So you take
Yes,
care
sir.
of them, and we're off the record.
Yes, sir. Thank you.
Thank you.
Thank you, Judge.